Everyone, welcome back to the Legal Path, your trusted channel for understanding Indian laws and their practical impact. In today's session, we are going to discuss Section 6 to 20 of Bharatiya Nagarik Suraksha Samhita 2023, which corresponds to the Constitution of Criminal Courts and Offices. By the end of this lecture, you will clearly understand how criminal courts are structured under BNSS, the difference between judicial and executive magistrate, the role of public prosecutors and the newly introduced director of prosecutions, and how BNSS modernized the criminal justice system by simplifying the old CRPC structure. So stay till the end because these 15 sections form the foundation of the entire criminal procedure system in India. So let's begin our journey, the legal path to understand justice under BNSS. This section from chapter 2 of BNSS titled Constitution of Criminal Courts and Offices. They define the hierarchy of criminal courts, territorial divisions, and the structure of prosecution. Essentially, it tells us the who will try the case, where, and under whose supervision. Think of it as the blueprint of criminal justice machinery. Section 6, Classes of Criminal Courts. Every state will have four main classes of criminal courts: the Court of Session, Judicial Magistrate First Class, Judicial Magistrate Second Class, and the fourth one, Executive Magistrate. High Court and special courts like CBI or NI courts are separate. These classification ensures that serious offences go to the high courts while minor offences are handled locally. Section 7, Territorial Divisions. The state is divided into session divisions and each divisions may contain one or more districts. This allows efficient jurisdictional management. For example, a murder in Jaipur will fall under the Jaipur Session Division, a theft in Ajmer under Ajmer Divisions. It ensures clarity about which court handles which area. Section 8, Courts of Session. Every session divisions will have a court of sessions presided over by a session judge appointed by the High Court. High Court can also appoint additional session judges if needed. Key update under BNSS. The point of assistant session judge has been abolished. This reduces the confusion and streamlines the hierarchy. Session court handles serious offences like murder, rape, and dacoity. Section 9, Judicial Magistrate. Every district will have a judicial magistrate of first and second class, set up by the state government in the consultation with the High Court. The High Court appoint these magistrates can even assign power to certain civil judges. The state may also create special magistrate for particular classes of cases, for example, traffic or municipal cases. Section 10, Chief, Additional and Subdivisional Magistrate, Judicial Magistrate. Once a magistrate, that is first class, is appointed as the Chief Judicial Magistrate (CJM) by the High Court, there may also be additional CJM with the same power. In every subdivision, a subdivisional magistrate, judicial magistrate, may be appointed to oversee local courts. This ensures smooth supervision and accountability in every district and subdivision. Section 11. Special Judicial Magistrate. The High Court can authorize experienced or retired officers to act as a special judicial magistrates. Their power are limited to particular area or class of cases, and their term is 1 year at a time. These appointments help clear blockages and speed up small or local cases. Section 12. Local jurisdiction of judicial magistrates. Each judicial magistrate can exercise power only within the area assigned to them by the state government. This ensures there is no overlap or conflict between different courts. Section 9. Section 13. Subordination of judicial magistrates. The hierarchy is simple, very simple. Session judge supervises the chief judicial magistrate (CJM). CJM supervises other judicial magistrate. This chain of command ensures administrative efficiency and proper case distribution. Section 14. Executive magistrate. These are administrative officers handling the law and order functions, not judicial trials. The state appoints executive magistrates and one as a district magistrates, that is DM. Additional DMs can also be appointed. If the DM's office becomes vacant, another officer temporarily takes charge. Section 15. Special Executive Magistrate. Similar to Special Judicial Magistrate, the state can appoint special executive magistrates for particular area or cases. They help manage emergency or special administrative situations. Section 16. Local jurisdiction of executive magistrate. Executive magistrates also have a local jurisdiction within the district or the subdivision assigned by the state government. This ensures efficient handling of preventive and the administrative orders. Section 17. Subordination of executive magistrate. All executive magistrates in a district are subordinate to the district magistrate. The state government may issue detailed instructions define subordination and powers. This maintains order in the administrative machinery. Section 18. Public prosecutors. The state appoints a public prosecutor for the High Court. Additional or special public prosecutor may also be appointed. They represent the state in a criminal precautions and ensure fair trial process. Section 19. Assistant Public Prosecutors (APPs). Every district must have assistant public prosecutors to conduct cases in magistrate courts. If none are available, the district magistrate can appoint one after giving 14 days notice to the state government. Here's the important rule. A police officer involved in an investigation cannot be appointed as an assistant public prosecutor. This maintains the separation between the investigation and the prosecution. Section 20. Wait a minute. Okay. Directorate of Prosecution. A major reform under the BNSS. The state government can create a director of prosecution headed by a director with a deputy director and assistant director at a district level. Eligibility. Director or deputy director, advocate with 15-year experience or a session judge, or assistant director, advocate with 7-year experience or a magistrate first class. The function monitor trials based on severity of punishment, review police reports, expedite trials and oversee appeals, strengthen the coordination between police and courts. This institutionalize prosecution, ensuring professionalism and accountability. Here's a summary of sections 6 to 20. These sections create the foundation of India's criminal justice system. Courts are structured in a clear hierarchy. Jurisdiction and supervision are well defined. Prosecution is made independent through the directorate system. BNSS simplify the old CRPC and brings transparency, speed and efficiency. Key changes, BNSS versus CRPC. Assistant Session Judge post was removed. Director of Prosecution newly introduced. Clear structure of subordination and jurisdiction. Enhance the administrative accountability and digital oversight. Here's the BNSS modernize India's 50-year-old procedure law to match today's need. What we need today. So here's some examples. Okay. Murder case heard by a court of session, monitored by director of prosecution. Theft case heard by magistrate first class, APP prosecutes. Public order issue, executive a magistrate issue preventive orders. These example shows how each level fits in a judicial chain. So friends, section 6 to 20 of BNSS are not just about numbers. Okay, they are about the structure of justice in India. They define who will hear your case, who will prosecute it, and how justice will flow from local level to the High Court. If you understand this well, the rest of BNSS like arrest, bail, and trial will make a complete sense if you understand this very well. Hope you understand. I'll explain it very well in the next chapter, the remaining sections. Okay, so don't forget to like, share, and subscribe to the legal path if you need it. Okay, where the law becomes simple and meaningful. Thank you for watching and see you in the next class with the section 21 onwards of BNSS. Have a good day.